Hi, and welcome to another product knowledge video. Today's product knowledge video is on a very important coverage in insurance called employment practices liability insurance. The presenter for this program is a person who really knows it. His name is Robert Bob Sargent. He's the president of Tenant Risk Services. He was a past president of NAPSLO, and that's the big organization for specialty coverages. It's a very high-ranking, well, that's as good as you can get in the industry, and I'm very pleased to have him. He's done others for us, too. He has an organization that is a wholesale broker, underwriting manager, and agents deal, again, with the wholesale brokers, underwriting managers, and so forth. He specializes in professional liability, errors and omissions, cyber risk, directors and officers, and employment practices liability, like we're going to be talking about today. So, Bob, let's start out by asking a very good overview question. What is employment practices liability insurance?
Oh, well, thanks for having me, George, and welcome. And as you've figured out, employment practices liability insurance is sort of a mouthful, so people tend to call it EPL, and I will as well. It goes a little faster.
Okay.
EPL is designed to protect organizations from employment-related claims, and typically these fall into three main buckets: wrongful termination, discrimination, and harassment, which is typically sexual harassment.
All right.
If you want to flip to the next slide.
Absolutely. We'll go right there, and we'll see more key facts, key points. All right. What's a buyer need to know about this? What do they have to keep in mind?
Well, there's a variety of things. I would start by saying that the exposures vary, and the policy forms vary a little bit as well. And so we'll be covering some of the key points today, but a buyer ought to, pay attention to some of the nuances with the help of, his or her broker and specialty provider as well.
All right.
Secondly, the exposures vary by class of business and geography. So, one type of business will have a different employment exposure than another, and because it's very regulatory and legal driven, the territory or the state has a big impact as well. And a couple of other things, deductibles vary quite a bit. Sometimes it's included within a D&O policy, and some not. So that, I would keep those key points in mind if you're looking at the coverage.
Well, one thing I always heard about was wrongful termination. How about what does that mean?
Well, good question, and this is a good place to start. As we just mentioned, there's three main buckets plus a couple of other coverages, and wrongful termination is probably the first one that comes to mind for most people.
All right.
A policy wording might define it as, for example, wrongful discharge or termination of employment. But it goes a little bit beyond that. It can also include like refusal to employ or lack of promotion, wrongful demotion, for example, and a claim situation might include something. Well, how about this? An employee was injured and subsequently terminated, and that employee brought a claim claiming he was terminated because of his injuries, not because of performance, and a lawsuit ensued from that.
We're seeing a lot of this kind of stuff in the news these days, aren't we? Boy, I imagine those are. I imagine this is one of the coverages that's really coming to affect a lot, and I won't mention any particular because I may get sued too. How about that? All right. Well, now that's wrongful termination. What's another one of the points there? How about? Well, I know what you're going to come up with. You're going to say discrimination. Same kind of deal, huh?
Discrimination, yes, that would be probably the next important bucket. It's a core coverage of these policy forms, and it really involves employment decisions that are discriminatory, hiring, promotions, that kind of thing. And again, one example of what the wording might look like in a policy would be violation of any common or statutory federal, state, or local law prohibiting any kind of employment-related discrimination. So it's really focused on a violation of a law or regulation that involves discrimination.
Could be a lot of things like age, race, I guess what else? With logic.
Exactly. So an example, actually this maybe a couple of real examples. After being terminated, an older employee sued for age discrimination. And this individual won because the employer failed to adequately document this individual's performance. So in that case, they won. In another situation, a healthcare company did not provide a special accommodation for an employee with a disability and then terminated that employee. So the EEOC got involved and alleged discrimination for failing to provide a reasonable accommodation under the ADA, and also retaliation for the employer bringing for the employee bringing the claim to the EEOC, and in that case, that was settled for $160,000. So, these can get a little bit
yeah, I'd say
complicated. And
I'd say the insurance is a lot cheaper than the $160,000, and that for sure.
That's for sure.
All right, well, give me. All right, what's another one of the points here?
Harassment would be the third bucket. And this is, people typically think about sexual harassment, but it can include other kinds of harassment as well, and also hostile work environments, which is a legal term. So in a policy, this one can get a little complicated, but an example of the wording would be harassment, including any type of sexual, gender, as well as racial, religious, and on, including workplace harassment by any non-employee. So that one is a little broader. And an example, a claim example would be simple. Some manager making sexually explicit comments in a meeting, which some employees are uncomfortable with, and therefore bring a claim against both the manager and the company.
Yeah, we've got a nice, we've got a big. I won't mention the network, but there's a certain big network that's really involved with this right now, and you know
Exactly.
who, and I know who, and everybody else does too. Man, I guess that was you couldn't possibly cover those big numbers with employment practice liability insurance that we're seeing, can you? I mean, those are multi-million, many million. Wow, I don't see how they did.
For a larger company, they would buy extremely high limits, and so they probably would have, insurance to cover at least some of that, if not all of that. But for a small to medium-sized company, they'd be buying less limits, but these things can get very expensive.
Oh, man, I can just imagine. All right, let's go to the next point.
So we talked about sort of the three major types of or segments of coverage: the wrongful termination, the discrimination, and harassment. There's a couple of other coverages that are important as well, and these are integrated into policies in different ways. So retaliation is the next one. It's relatively simple. It's the response by an employer to a threat of disclosure or some other action by an employee. For example, an employee may complain to a manager of some situation like a hostile work environment, and the employer waits a little bit of time and then fires the individual. And that individual brings a suit for wrongful termination, say discrimination, but really it's retaliation. And so from an employment liability standpoint, this segment is relatively simple, but it's extremely important.
I can see why it would be. It makes me think of terms like whistleblowers or something. I don't know if
exactly. Whistleblowers would come in under this segment.
Yeah, how about that? All right, and then one more here, I believe.
Yeah, well, we may even get more than one more.
Oh, I'm sorry. One more for right now.
We'll see. We'll see.
Right.
So third-party coverage is sort of interesting. It's not always included, but it relates to claims that are actually not directly employment related. it's some third party. Typically, it would be a customer, or could be a vendor, maybe even a competitor or something like that. It's generally harassment or discrimination, but again, third party, and it can include regulatory proceedings as well. Now, this can get a little bit complicated depending on the territory and the class of business, so sometimes this is not always included. But an example might be, say, for a real estate agent might get sued by a customer for discrimination, alleging that they were shown or not shown the same properties as similar types of people were, and in effect that real estate agent was discriminating. So that would be an example of third party.
I see. All right. Other coverages then.
Yeah, well, let's move to wage and hour. So this is actually conceptually relatively simple, but it is a real challenge. So wage and hour is coverage would cover defense for allegation that the employer failed to properly pay an employee. Typically, it involves overtime, but it also can include allegations that the employer didn't pay fully for the amount of hours worked. And typically the claims are brought under the FLSA, which is the Fair Labor Standards Act, or some state equivalent. It's not always offered. It's very much a function of the territory as well. So in some territories, it's extremely risky for underwriters, and so they might either not offer it at all or offer it with a sublimit. But it really, as I said, it's complex and can be confusing, which can lead to claims. And so, you know, the primary two areas are the employees, you know, which employees are not exempt from overtime. In other words, they're due overtime, and which are. So a lot of employers may not understand the letter of the law and have people classified incorrectly. And some of these stem from record keeping that's not completely up to date. So it's a challenge for employers. It's a very hot area for plaintiffs' attorneys.
I'll bet.
Insurers are seeing a lot of suits from this.
I can just imagine. I can imagine. Well, all right, you mentioned claims. Let's talk about claims a little bit here. What is a claim?
Sure. So what is a claim? And you know, this is really an important topic under this coverage because, you know, the definition of a claim is typically a written demand, but it can vary a little bit. And because the area is so complex, the question is what constitutes a written demand. So it certainly could be a letter from an employee, but because this coverage also encompasses regulatory proceedings like complaints to the EEOC, any indication of that kind of a proceeding can also be considered a claim. So, and with third party, it's a written demand as well.
Oh.
So let's go to the next slide and talk about
claims made.
So more about the coverage and claims. So employment practices liability is typically written on a claims made form.
What is that? What's claims made form? I've seen it, but I'm not quite sure I understand it.
Great question. So a claims made form is a policy that responds to claims that are made during the policy period. So it's not when they occur, it's when the claim actually occurs.
That's it. That's the key. Right. Yep. Okay.
And again, we're talking about written demand. So once a claim is made, the question is, who's going to defend it? And this can get a little bit sticky sometimes between insureds and their insurers. And so most policies have a provision in there that says that the insurer will be the one that decides. Now, there is some flexibility for certain people, but the bottom line is that there should be an expert handling the defense. So, you know, if someone's brother is an attorney that does corporate law and you want him to handle this, the insurer is probably not going to agree. Most insurance companies who specialize in this coverage have what are called panels, which are sets of attorneys within a certain area. And they're actually, they tend to be quite flexible within that panel. So if an insured has a preference of someone who's on the panel, the insurer will typically agree. But if there's a strong preference for an attorney to handle any claims that come in, that should always be hashed out before the coverage is put in place.
Got it.
The insurers tend to be very inflexible if that request comes in at the time of a claim.
I bet so. I bet so.
Yep.
Okay.
Yep. So, some other things, limits vary, limits that are purchased vary based on the size. Typically, at the smaller end, $1 million would be the base. Every once in a while, you see a limit below that. But $1 million in coverage and up. So it really depends on the size of the company and again, the territory as well. Deductibles actually are more a choice of the insurer than the insured, not 100%, but typically.
Yeah.
And deductibles tend to be set based on the insurer's perspective of exposure. So if it is a tougher class of business, in California, for example, the deductibles tend to be quite high because the frequency of claims out there for tougher exposures tends to be high. And the deductibles ranged from, again, low hazard state, low hazard class to be, a couple $1,000 type of thing.
Wow.
Up to minimum deductibles, say in a tough class in California, could be as high as $25,000.
Yeah,
so
I can see why it would. All right, now you've talked about what's covered. Let's talk about what's not covered.
Well, actually, it's sort of interesting. EPL coverage is pretty comprehensive in terms of what is covered, but there are definitely some important exclusions. We'll start, the first one that is really important in this coverage to keep in mind is prior knowledge. So if particularly, I won't get into all the technicalities, but if a company is a first-time buyer, they will need to be fairly sure that there is no knowledge within the company of an event which could cause a claim, because that will definitely not be covered. So any situation where, particularly for a company that has coverage going forward, if they know that there's a situation where something could happen, they ought to report it and get it set with the insurance. So if something comes up, it will be covered. But you could have a situation where an employee wrote a letter, say a couple of years ago, and said, you didn't treat me fairly, I should have been promoted, and I'm going to go get an attorney. And that may be innocuous and you smooth things over, but technically that's a written demand and that's a claim. So it's a complicated area. And then a couple of other things that are important, prior and pending, any claims, it's called prior and pending litigation, any claims that arise out of some lawsuit that's been going on for a while would typically not be covered. Wages are typically excluded. So we talked about wage and hour coverage.
Mm-hmm.
If a court determines that the employer did owe additional wages, they would not be covered. The defense would be covered, but the wages would not. And the thinking there is those are money that or wages that the insured should have paid anyway. So the question is whether they were due or not. But if they're due, the insured should pay those. So those typically would not be covered. And then you get into sort of the standard stuff, things like punitive damages, fines, and penalties generally are not covered. Taxes, criminal acts. Although criminal acts in EPL coverage is, again, it can be a sticky area. So you could have a situation where an individual engaged in a criminal act, and then there was a lawsuit against that individual and against the company for something employment related. And with respect to the criminal acts of the individual, they would, of course, not be covered. You can't cover criminal acts. But there's a provision in virtually all policies called severability, where the insurer would say, fine, we'll cover the stuff that's supposed to be covered, and we won't cover the parts that shouldn't be covered, and we'll separate those out. So that's typically how that is handled. There's one other important exclusion in most policies, and again, this in some cases is negotiable, but it excludes takeovers. So if a company is acquired and half of their employees are fired, the intention is not to cover that.
Oh, yeah, I can imagine. Gosh, can't you?
Yep.
Wow. Well, let's talk about who. Now let's move to who, if we can do that. I think we got the idea who is covered. I mean, what's covered and what isn't.
So who is covered is actually relatively simple and sort of consistent with most other coverages. Obviously, the entity is covered and typically subsidiaries, and then all employees and officers, directors. In some cases, if there are a lot of independent contractors, if that's the business structure, they can be covered, and for nonprofits, volunteers are typically covered as well.
I begin to understand. It's amazing coverage, isn't it? It's so. I say complicated. It's probably. I know how many times you've done it in your life. Many times. It's still complicated for you after having done it all these years.
It is. It's the challenge is that unfortunately, the legal environment that employers face today is very tough. It's complicated, and the employment practices liability insurance is designed to respond to that. So, yes, the coverage gets.
I can see why it would. Yeah.
Complicated. Yeah, and so it really any employer, any organization that has employees should be buying this.
I can see that. Now, what are the sources of claims? What's that mean?
Well, everybody thinks EPL is because it's employment, it's just employees, but claims can also be made, as we talked about, under third party from customers or vendors. But there is a regulatory element to this that is actually quite significant. So unlike many other coverages, both the state and federal regulators can take action and can in fact take action by themselves. And that can be a pretty significant source of claims.
Wow, that's interesting. You don't see that very often. Any other kinds of coverage, do you? All right. Well, let's. All right. What are you? I know you write these things. Or you do the underwriting, or what does that underwriting people need to understand is trying to figure out what it costs and what it's going to be covered and all of the details. Who does that?
Yeah, well, whoever's underwriting, yes is the answer to your question, and we do, and underwriters are. I think for buyers it's important to understand the perspective of underwriters in the process, and so I think the starting point for underwriting should be pretty obvious to most people. It's really a function of the number of employees in the organization, to some extent the revenues as well. We talked about class and location. So class would be, what type of business is it? Because some businesses have higher frequency claims than others. And we talked a little bit about location, California being one example where the regulatory or employment climate is pretty challenging. And that's sort of higher as well. But then, there's some other things that underwriters will look at, and I put it under maybe 2 or 3 different buckets. First of all, call them employment metrics. So how much turnover is there at the organization? Because turnover is somewhat of an indicator of claims. Also, what's the compensation profile? Some underwriters want to get an idea of how many highly compensated individuals there are relative to the entire employment in that company, because obviously higher compensated people tend to have, when they have a claim, it tends to be a little higher value. So those would be two of the metrics. And then prior claim experience is actually an indicator of future claim experience. So underwriters will look carefully at that. And they are paying, unlike some classes, they are paying pretty close attention to risk management practices. What are the employment practices? How well does the HR function? go, things like documentation and that kind of thing. So those would be sort of, I guess, some of the key points that underwriters would consider.
All right. Well, that's fascinating. I'm glad I'm not an underwriter. I'd probably just, I don't know if I could ever understand it. Boy, oh boy, this is fascinating. Okay, go ahead with what you were saying. Excuse me for interrupting.
Oh, sure. So where are we on claims and the employment environment? We talked a little bit about that. It's sort of challenging for employers and varies by state. Um, I think, and we talked about claims being an indicator of subsequent loss experience as well. But because of the complexity of state and federal laws and regulations, it's a challenge for employers and costly for employers to comply. In some cases, some of these regs conflict. There are a number of different regulatory agencies that are active.
Mm-hmm.
Certainly at the federal level, EEOC and state equivalents. A lot of states have some pretty aggressive regulatory agencies. So they're actually a pretty active, unfortunately, plaintiff's bar. Um, it can be easy money for plaintiffs' attorneys if they have the right case. Litigation for these cases, because of the complexity, is expensive. So there is, between the distraction for the employer and legal fees, there is very high incentive to settle these cases. So there's a lot of activities and a lot of settlements. The trends are, not in the right direction. Frequency is up, lawsuits are up. Part of that is new regulations. Part of that is media attention, as you referred to earlier, George.
Mm-hmm.
Severity is also up. Litigation costs are up. And as I mentioned, complexity drives that. For smaller settled claims, those averages are up a bit as well, which pushes deductibles up. So, just to put it in perspective, for sort of your not standard case where it goes away, but standard case where there's some litigation, defense costs can be $200,000 to $300,000, just the defense costs.
Brother.
If you win. And the other problem is, I mentioned management distraction. I mean, these things can be distracting to management, and they go on for a while. So the average time for resolution of these types of claims is 18 to 24 months.
Oh boy.
And we talked about defense attorneys. It's important to have someone who really knows what they're doing, and the insurers are very helpful with that.
I can imagine. Well, I imagine that there are also a lot of these that are pretty hard to place, aren't they? These accounts.
Yeah, there are some, and it's interesting. We talked about the class and geography issues, but poor risk management can lead to losing a case when it arises. But there are also situations where a company may find itself in financial challenges,
Mm-hmm.
and then because of the expense of some of the HR function, they sort of ratchet that back, and that can create problems as well. And certainly, acquisitions and sales of company where you have some pretty substantial changes can drive claims as well. And then as we talked about class, I mean, things like hospitality, auto dealers, law firms, and healthcare organizations, just off the top of my head, would be some classes that are a little bit harder to place. We talked about California as a tougher jurisdiction. West Virginia is there as well. Insurers pay a lot of attention to what is going on, not only within their own claims, their book, but within the employment environment in general. So they're paying pretty close attention to this. And that's, for example, we talked about the higher deductibles in California. That's really a function of what they see the cost to deal with even a claim with very little merit, maybe just sort of the state equivalent of an EEOC complaint that goes away. That's expensive still in California, so because of the process. So, that pushes deductibles up on these coverages.
Yep.
So what is a company do that has a more difficult
Mm-hmm.
employment exposure.
Mm-hmm.
There are carriers that specialize in doing this. We work with them. That's what we do. And so working with a broker through your retail agent who has a lot of expertise in this and knows the underwriters that do this harder to place stuff is how you get it done.
Yeah. Risk management. That's a big term. I mean, it's a small two words that mean a whole lot there. And that I can see now the risk management is on the part of the employer. Does the agent bring in the risk management program to them? I hope, or not.
Well, no, I think, sort of two things. First of all, unlike a lot of talk about risk management, which helps maybe do some prevention in other lines of business, but maybe marginal impact, risk management here for EPL coverage is incredibly important. So having appropriate HR policies and procedures, like a well-written employee handbook, is important. Effectively documenting the HR process, good record keeping, thorough personnel files, conversations are documented, having the right forms, having the right procedures, all of that is really important. And the insurers actually pay attention to this. So, and then you asked, secondly, the question about do insurers bring this? I mean, I guess the traditional source of a lot of this is attorneys who specialize in HR, and they can help employers with that. And my recommendation would be that everybody should do that, because the state laws are so specific that you need someone local to provide appropriate guidance. Having said that, particularly for smaller organizations, most of the EPL insurers do have risk management programs that are actually pretty effective. A couple of these examples might be they will provide free access to an attorney. You can call an attorney, get them on the phone, say, I have this situation, what do you think?
Mm-hmm.
And that they won't, not for a lot, but they'll give, half-hour conversation, hour conversation, that kind of thing. So having that ability to talk through a situation and what might be the appropriate direction to move is really beneficial. The other thing that I found is incredibly valuable is some of these insurers will provide templates. Like everybody should have a fairly thorough employee handbook for the state you're operating in.
Mm-hmm.
And an insurer will provide a template. And, my suggestion would be you still have your own counsel who understands the intricacies of your company, do the manual, but the employee handbook. But if you can take a template, you can start to edit it based on your own company, and then you take that to the attorney. You can actually cut the cost down quite a bit. So those would be two examples of really valuable information, risk management information that are provided typically by insurers with the insurance. So, if you're a small employer and you're paying, $1,500, $2,000 for EPL coverage, and all this other stuff comes free, there's good value there.
I could see that there would be. All right, now, what happens when the claim is put in? Or what happens when the customer or the client has a claim?
Well, like any good insurance agent, when you have a claim, you report it immediately.
Well, I understand that.
Mantra in our business.
I understand it. I was thinking about the organization, the buyer.
Yeah. So I think obviously the buyer should be reporting any situation right away. And if there's an event that's occurred that the buyer is worried about, they should have a conversation with their insurance agent, maybe the carrier, and maybe their attorney. So definitely getting good advice. I will tell you, though, related to this, what is probably as important is recognizing when a claim has occurred. And remember, the definition typically is a written demand. You should go look at the policy and see exactly how it's worded, but typically it's a written demand. But what is a written demand within the employment realm can be a challenge. So, for example, we had a client that let go a manager, and that manager was not happy and got an attorney, and they had a meeting, and the attorney wrote a threatening letter and suggested that they were going to file an EEOC complaint and move it on. And nothing happened for probably 8 months, and then they got a notice of an EEOC of the complaint and that there would be action, and nothing happened for another 6 months, and they were not completely up to speed on what was going on with the EEOC, and then ultimately they got the right to sue approval from the EEOC and immediately filed a lawsuit, which was reported to the insurer, and the insurer said, well, wait a minute, this goes, there were a number of points before the lawsuit where you should have reported this, and certainly when you got this threatening letter, even though it was, polite and soft, the attorney made it clear that what they were intending to do, and that should have been reported at that point. So recognizing what is a demand and recognizing a situation that could lead to a problem are really important.
Yeah, I can see it. All right. Well, as we go down here, as we end here, let's talk about the practical. How does it really work? I mean, how do I get it?
Well, EPL is generally provided two ways. It's provided, as a standalone product, as you would expect, but it's often packaged with D&O, and either is fine. The EPL coverage that's packaged with D&O tends to be very comprehensive. I think the only point I would make is that if you are an organization that really needs D&O, I would either through a separate EPL policy or through a separate limit on the D&O policy, I would separate the limits between EPL and D&O, because what you really don't want to do is have an EPL claim that eats right through your D&O limits. So that's an important takeaway if you're buying coverage package with D&O.
Okay. All right. What about the, I guess the next one is how to get it.
Well, it's like any other coverage. There's an application. The underwriters want information. We tend to start the process with a short form. We have our own short form app that underwriters have agreed to use. But the underwriters want some information. I think the important point to remember about applications is they are representations to the underwriter of what reality is. So it's very important that they be that applications be clear and accurate.
Yeah, I've got it, I think.
Yeah.
That's what the agent's going to have to do anyway, and that's what the agent does. That's why we have you tell them about it, and that's why they're going to be talking to their agent. Well, we've talked, you've given a good outline here, understanding and everything else. What you got? How would you conclude on this?
I think the important points are that exposures and policy forms vary a little bit. You need to make sure you've got an expert working with you. Understand that the class of business, the type of business you are, and where you're located will be one component of pricing. Deductibles are important, risk management is important, and separate limits if you're going to package it in D&O. So those would be my key points.
Well, I think those are important, obviously, ones, and we need to know it. I think the message here is that that the agency sponsoring this particular presentation, product knowledge video, can know a lot about the product, but they also have people, general agents, wholesalers, and so forth, like you, who really are professionals and deal with it all the time. And I think that's really the main function. Well, it's the main function of an independent agency anyway, to be able to represent the client with a lot of different coverage possibilities. But I think this particular one gets my attention from the complexity of it, and I'm glad you're around there, Bob, to help agents to cope with the thing. So may I just suggest, thank you, and I would like to suggest that the rest of you, it says down there, contact me if you have an EPL, you want possibility, hit contact me, and it'll come right back to the agency and take it from there. So good luck, and again, Bob, I do thank you very much for your help as usual. Okay, thank you.
Thank you, George.